Hi, my name is Euodia Syefela Lumempow. Now I will tell you about international civil law cases. The cases of Prada SPA and PT MPP. Intellectual property rights are personal rights that allow creators or inventors to register their intellectual property so that they get legal protection and can enjoy the benefits of their intellectual work. Legal protection of intellectual property rights itself is regulated in Law Number 20 of 2016 in Indonesia. One part of intellectual property rights is a brand, either in the form of a logo, image, name, color arrangement, word, letters in 2 or 3 dimensions as a differentiator from other brands. So, trademark registration is important for the owner of such intellectual property rights to get legal protection as well as the benefits of trademarks ownership. However, with the development of trade and industry nowadays, various disputes involving intellectual property rights have arisen. One of them is the disputes experienced by Prada SA against PT Manggala Putra Perkasa with the dispute over the Prada brand. In the case above, legal remedies from ordinary to extraordinary are used in the form of a review to the Supreme Court. This is related to the first to file principle, which is used by Indonesia in registering a trademark, even though Prada SA has been registered abroad. However, because PT Manggala Putra Perkasa had previously registered a trademark with the same name, the trademark registration by Prada SA could not be carried out. This case began when the owner of Prada Italy tried to register his trademark in Indonesia. It turns out that the Prada brand has been registered by an Indonesian businessman. In the first stage, the commercial court rejected the plaintiff's claim on the grounds that Indonesia uses the first to file system, so that the first registrant has the exclusive right of the mark in question. At the cassation level at the Supreme Court, this case was still won by Indonesian Prada entrepreneurs. However, at the judicial review, the Supreme Court granted the Prada SPS lawsuit against Fahmi Babra and the Directorate General of Intellectual Property Rights. Article 16 to Article 18 AB also regulates 3 main determination of international civil law. In this case, PT Manggala Putra Perkasa, which is a company established under Indonesian law, this company will be bound by national law and can also use the lex domicili principle so that a lawsuit can be brought to the Indonesian court. Next is the theory of qualifications that can be used both lex fori and lex causae. In this case, because lex causae is more easy to use due to lack of information on judge regarding the laws of other countries, laws of the plaintiff's country. They can use lex fori so that judges can determine the use of national law in this international trademark dispute.